She is a judge, a United States judge of the District of Arizona. She was confirmed in 2014 by President Barack Obama, and she is the first Native American woman and enrolled tribal member to serve as a federal judge. She is a member of the Hopi tribe and served as a judge at the Hopi Appellate Court. Before her appointment as federal judge, she also worked as a United States attorney appointed by President Bush. She also served as deputy counsel for the Senate Indian Affairs Committee with Senator John McCain. We are very excited and grateful to have her here today. Please welcome Judge Tula.
I am very proud of this side of the room right here because you've lasted to the 11th hour. This side, they're kind of, falling like flies. I'm very much aware that I stand between you and, is it homecoming this weekend? And so there's all of these events going on across campus, and I apologize because I feel like I'm speaking in my head. This is the first time that I'm using this device. Matt Fletcher apparently has taken some lessons from Britney Spears or something. He just walks around and it's like part of his anatomy. But this is a little bit unnerving, so if I feel like I'm yelling, please forgive me. I promise you that I'm not going to be intellectually stimulating. How's that? I mean, I felt in some moments like I did in law school when I was sitting there thinking, okay, I think I know what was just being talked about, but it's just really theoretical. It's not going into my head at the moment. I'll have to think about it for a little bit more. But I really do appreciate all of the intellectually stimulating discussion that we had all day long. It's really, for me, it does take me back to working on very pressing issues of Indian law, and it's really sort of, in my mind, fascinating to see that while a lot has changed, so much of it has stayed the same. As I was talking earlier with, in comment to Professor Fletcher's discussion, and then listening to Professor Skabeen talk about IGRA, I was there during those IGRA hearings at the Senate Indian Affairs Committee where we had, the New Jersey governor and so on and so forth, all of that really interesting time, and then also sort of fighting off some of the challenges to ICWA back in the 90s, and it's just so, for me, fascinating to see that not a whole lot has changed. And so, again, I'm not used to this. So if I take it off and start using the mic, then you'll know why. So I'm not going to be intellectually stimulating, but I'm hoping to be very practical because I really want to give an opportunity for a lot of the law students here to understand what it's like to practice in federal court, to understand what the day-to-day challenges are, not just of being a federal judge, but also working in a district that has a very diverse population, has Indian country, and then also working in some respects in the Ninth Circuit and having to interpret some of the circuit law, and then of course on top of that the Supreme Court precedent. I get a lot of times questions from people that go along the lines of this, you're a Native American, you're a member of a tribe, what's it like to be a judge? Well, I think many of you, some of you who've worked in the state court systems, some of you who've worked in tribal court systems and in the federal courts know that it's just a lot of research, a lot of writing, a lot of reviewing precedent. And after all, when I was going through the confirmation process, one of the critical questions that all of the senators wanted to know is, what is your judicial philosophy? And for me, that was a very difficult question in some respects because I knew that they were asking in the context of the federal judiciary. I had been an appellate court judge on the Hopi tribal court, and judicial philosophy in that context meant something different. And so one of the principles that I always adhered to is, and you hear it in these confirmation hearings over and over again, it's precedent stare decisis. And what does that mean? Well, I think at the very basic level it means that the people in common, they have to have some reliance on the stated law as it is today. And so that's sort of the basic starting point. What is the law as it is today? And so what I thought I'd talk to you a little bit about is just sort of some of my observations, and there were really good questions that I want to intersperse here. And there were nuggets of discussions in a different context. I keep thinking, oh, they're gonna talk about what I was gonna talk about, but then they just kind of skirt the edges. So what I'm going to talk about really is applying some of these issues that have been raised in a real practical sense when you're dealing with an ongoing controversy in federal courts. But I want to give you a little bit of a backdrop of where we are generally. So what you have here is the Ninth Judicial Circuit map, and of course there are 13 judicial circuits, and I'll just rattle them all off for you. Alaska, District of Arizona. So California has 4 districts: Central, Eastern, Northern, and Southern. And of course, Hawaii, Idaho, Montana, Nevada, Oregon. And the state of Washington is also broken up into 2 districts, Eastern and Western District. And of course, the Ninth Circuit has the District of Guam and the Northern Mariana Islands. And I wanted to also give you, and this is actually taken from the Ninth Circuit's websites, and the little kind of circular little dots denote where the arguments are generally held. Now, from time to time, the Ninth Circuit will hold oral arguments, and oftentimes they will come to law schools. So the Ninth Circuit has come to ASU when I was a law student. I don't know if they've gone to U of A recently. And have they come to this law school? And so I think it's a wonderful opportunity to have, to hear an oral argument. And one of the wonderful things that I got to do just last fall was, because of all of the vacancies in the Ninth Circuit, we get periodically these requests to volunteer to sit by designation on the Ninth Circuit. And so I raised my hand, and then a year later they say, oh, here are all the cases that you're going to hear. And oh, by the way, 6 of these are set for oral argument. And oh, by the way, you know, here's when your briefing memos are due, and you're like, oh my gosh, okay, well. So I sat on the Ninth Circuit last December, and it was a lot of hard work. It was very interesting. The cases that I sat on were interesting, and I also got a very sort of a immersion into the decision-making process, which is fascinating to me, and the speed at which the circuit judges work. I just have a lot of admiration for them. And I actually sat on a panel that included Sandra Ikuda. And I studied a little bit about her and some of the decisions that she wrote, and I was really fascinated by her because she was a former law clerk of Sandra Day O'Connor. And when she was sworn into the Ninth Circuit, Sandra Day O'Connor swore her into the circuit. And having met Justice O'Connor about a year prior, Justice O'Connor was asking me about the panel that I was sitting on, and I mentioned Sandra Ikuda, and so I had all of this background information about her, and I didn't realize what a fascinating individual she was, and that she actually also clerked for Alex Kaczynski, so that was sort of interesting as well. So it was for me, it was a really almost an intimidating situation to be sitting on a panel with someone with the intellect of Sandra Ikuda, and her writing style is just, it's pristine, I think. And I've come to learn since that, it's kind of an interesting tidbit, many of us hear routinely that the Ninth Circuit is the most overturned circuit in the Supreme Court. Well, Sandra Ikuda's decisions actually happen to be the ones that the Ninth Circuit tend to disagree with, and I think the last session, Sandra Ikuda's decisions were affirmed. In other words, the Supreme Court relied on Judge Ikuda's analysis in all of the reversals in the Ninth Circuit, which is really kind of fascinating to me. I didn't realize people are out there gathering this data, but in any event, somebody is. So I wanted to also give you an idea of the Ninth Circuit in terms of Indian country. I learned also from Professor Fletcher there are 573 federally recognized tribes. I'm going to have to update my data because the last count I had was 567, so 573, good for them. So you see in the Ninth Circuit there is a robust number of tribal communities, tribal lands that fall within the jurisdiction of the Ninth Circuit. Let me go to this next slide. This is Alaska. So I think this is right, 227 Alaska Native villages, roughly. And going back to the lower 48, as they would call it, you look at where the greatest concentration of tribal communities are, it's California then, 108 rancherias roughly, I think. And then of course, well, here in Montana, what is it, 12 tribes? And Idaho, of course, Arizona. And so you now get the sense of the reality that there are a lot of tribal communities, a lot of tribal issues, a lot of Indian jurisdiction issues that will be decided by the Ninth Circuit generally. And so one of the questions that I don't want to forget was a question I think posed over here about are judges required to have some knowledge of federal Indian law, or at least some idea of what it is? And the answer is no. Federal judges are not required to have that knowledge. And the interesting part about that, though, is thankfully in the Ninth Circuit just last month, all of the chief judges of the district courts that sit in the Ninth Circuit all had a meeting here, in fact, at the Holiday Inn down the road that we're staying at. And I was invited, as was Judge Morris and Judge Roberto Lang from the district court in North Dakota, to give a presentation on some sort of Indian law issues that have arisen in the Ninth Circuit. And probably a fourth of the sitting judges there, and these are magistrate judges, district court judges, probably had no idea what we were talking about. But the rest of them sort of looked like, oh, you know, like the light bulb went off that, oh, I had a case that had that implication. And so one of the suggestions that we made, and our administrative office of the U.S. courts were there, we suggested that possibly this Ninth Circuit Chief Judges panel might want to consider having a small subcommittee just dedicated to gathering information or case developments in Indian law. And so at the end of the presentation, the administrative officer who's sent by the courts in Washington, D.C., said, I'm going to take that to the broader body that makes these decisions, and we think it's a really good one. And then I walked out of the room thinking, oh God, they're gonna ask me to serve on it. always volunteering unwittingly, but I'd be happy to do it. So I hope that that was sort of laying the foundation for future education of federal judges, at least in the Ninth Circuit. And let's hope something comes of it. So I want to talk just generally about my observations and my backyard, what I'm dealing with. I'm sure many of you have been to Arizona, and you probably do recognize this map. It's used quite a bit. So there are 22 federally recognized tribes in Arizona. They're denoted by the little small boxes on the map. About 32% of Arizona is itself Indian land. A greater percentage, in fact, is federal lands, BLM, U.S. Forest, and so on. And of course, we have one of the largest native nations in Arizona, which is the Navajo Nation, and of course its land base goes into 2 other states. And then we have some very, very small tribal communities as well. But some of the other challenges I think were mentioned earlier today. We do have a couple of tribal communities that have Aboriginal lands on the other side of the Arizona border, that is in Mexico. And those situations are, specific and unique to mostly the Tohono O'odham Nation. And that would be a whole different seminar to talk about. Each tribal nation is unique in geography, in economic development. Some of those tribes are engaged in robust gaming. A lot of them have economic development partnerships with private companies, the state. Some of them have done tremendously well with gaming resources. Others, like my tribe, cannot, because we are landlocked, surrounded by the Navajo Nation, along with some very hard to reach tribal communities like the Havasupai, that some of those tribal members still reside on the bottom of the Grand Canyon, the western edge of the Grand Canyon, along with the Wallapai. They're sort of out of the way places where gaming and economic development is just really very difficult. And so there are in different states of economic growth, but I think one of the observations that I've made over time is that the tribal communities themselves are still growing, they're thriving, and the populations are growing and thriving. And you see there that the description I have is we have 1 judicial district, but we have 2 divisions, a Phoenix division and a Tucson division. And what does that mean? That means that, so this is roughly Phoenix, and everything from about this line going through San Carlos this way is handled by the Tucson District Court. And then everything north, inclusive of Maricopa County and north, is handled by the Phoenix District Court. And I want to talk to you a little bit about the types of cases generally that I've seen over time. And then sort of talk just generically about some of the sort of Indian implication cases that I've seen or some of my colleagues have handled. Of course, in the federal district court, we are courts of limited jurisdiction. We are governed by Article 3, and we have, of course, there has to be the requisite amount in controversy and diversity of citizenship or specific federal statutes that are invoked to let us hear those cases. And I tell you every day I'm thankful for our limited jurisdiction. And I was commenting to Rebecca, I said, you know, if I had my own little lobbying firm that I could, if I was permitted to lobby the Congress, I would ask for raising the amount in controversy. Because when you think about it, you know, everyone can make our threshold amount. So it makes case management quite interesting. So I pulled the last available data that I had for my court specifically, and that was the full month of August. So giving you a snapshot of my federal cases in August, I had 373 pending civil cases. They involved various cases of Social Security appeals, personal injury, labor law cases, tort cases, civil rights disputes, patent law, antitrust, trademark, contract, medical malpractice. The sky's the limit. Of course, we have a lot of state cases that get removed into federal court, and then the parties battle out whether or not it should be remanded or whether it should stay to the court. So that's a whole separate group of cases. And the one sort of wide-eyed area for me in the civil arena in Arizona specifically, and I think California is possibly in the same situation, was, believe it or not, about 45 every year, 45 to 47% of the civil cases that are filed are pro se prisoner litigation cases. And so what does that mean? That means that prisoners are filing 1983 cases, Title VIII violation cases dealing with poor facilities, poor management of health care, indifference, medical malpractice, issues dealing with not enough services for mental health treatment. And it was a very eye-opening experience for me, because not only do we expend a tremendous amount of resources in addressing prisoner cases, but we actually have in Arizona, we have a full bank of law clerks that are completely dedicated. They work for all of the district court and magistrate judges to address nothing but screening of these prisoner cases, screening the dispositive motions, and then helping us if the matter eventually goes to trial. And these cases they're of concern because they are resource intensive. And so, for example, in California and in Arizona, we've had class action lawsuits by prisoners that are brought against the state prison system for inadequate health care. And I know that in California, I believe it's the Eastern District of California, they have a special master overseeing a settlement agreement dealing with prisoner health care. I think that case was brought by the ACLU. Same sort of case occurred in Arizona. And that is slowly starting to, I won't say fall apart, but there's challenges on both sides to get out of the settlement, because there's still issues with what the ACLU and the other plaintiffs deem is inadequate health care. This is a concern because I think many of you in the room are very much aware that the rates of incarceration of people is not diminishing by any imagination. It's continuing to grow. And if you can imagine, like a state like Arizona, I was mentioning earlier about the disparity in sentencing. If you commit a crime in Arizona, a DUI homicide, there's an 8 to 10 year presumptive sentence that you're going to serve. And if you commit an act of, if you're engaged in child pornography, you're sentenced per image. And so in the state system, it's not unheard of to see an individual receive 50 years on those child pornography cases. And so what does that mean? Your prison population in the state and federal levels are aging. And so they're going to face the same sort of aging challenges that the general population does. They still need adequate health care and so on and so forth. So it's a real, in my view, it's a real crisis because we're sort of just, trying to keep up with the volume. So it's a really interesting sort of mix of cases. In the time that I have been on the bench, I have had Indian law cases rear their head in challenges to agency decisions. Of course, applying the arbitrary and capricious standard because it's very deferential to the agency because the agency is presumed to have the knowledge and experience in the given area. I've handled, and there are some interesting sort of nuanced cases that come to the district court in that sort of administrative agency review process, including benefits from Hopi and Navajo families who have been relocated due to the Navajo-Hopi land dispute. There was a whole agency that was established to develop those review processes as to which families are entitled to those benefits. Those cases are still coming through the federal court system. I've had cases involving Federal Tort Claims Act, primarily dealing with the delivery of health in Indian Health Service facilities. And those are primarily defended by, of course, the U.S. Attorney's Office, the civil branch of the U.S. Attorney's Office. And we do see some Fourth Amendment violations in terms of tribal law enforcement, allegedly doing something to infringe on someone's search and seizure rights. So they come by way of a civil rights complaint. I've seen a number of those cases. And I mentioned the habeas cases, and I have yet to see, but I have seen a couple of colleagues handle some federal court review of tribal court convictions that have been brought by way of a habeas petition by the tribal prisoner. They're rare, but when they occur, they're quite interesting, and they do require a delving into the tribal court record, which sometimes is not very complete, and that can be a challenge. Of course, we do have constitutional questions that arise, and I think the obvious questions that in the Indian law context, and I haven't had these challenges yet, are those that arise in the cases like the Bryant case or the Lara case, the equal protection or due process types of challenges. To be sure, it is extremely fascinating, and I know I'm very cognizant of your time, and I know we have a reception or a happy hour that some of you all have to get to, but I thought that I'd share with you some, and I think, and I'm sure Professor Fletcher and others are well aware of this, but just in the Ninth Circuit generally, I received this, I think all of our judges receive a daily blast of here's what we think is new and noteworthy in the Ninth Circuit, what's going on, what the most recent decisions are. So I think just 2 or 3 days ago, in Carroll Carter et al. Versus Washburn, I think it's now Tsuda. So here, my colleague that is on the 5th floor, he threw out a challenge to ICWA because by the time he reviewed the case, in his view, the challenge, and it was an equal protection challenge, that ICWA violated the Constitution. By the time he had rendered his decision, the adoptions had gone through. And so, and this was brought by the Goldwater Institute. And on the tribal side, it was joined by the Navajo Nation and Gila River Indian community. And when it got to the Ninth Circuit, Judge Schroeder, Owens, and there was a visiting judge from the 10th Circuit, they too held that the case was moot because the adoption had occurred. Well, just about 2 days ago, the plaintiffs, the Goldwater Institute, filed a motion for rehearing en banc. So a full en banc panel of the Ninth Circuit to determine whether or not the case should be reheard on its merits, because I'm sure, they argue it's capable of reoccurring. And so a decision will be made on whether or not to hear that probably within the next month or so. In addition, there have been some interesting treaty rights cases that are still sort of winding their way up through the Ninth Circuit. There was recently a case dealing with tribal tobacco, and there, again, this is another request to the Ninth Circuit for rehearing en banc, for the Ninth Circuit to reconsider 2 rulings finding that the tribal-owned tobacco company was liable for $58 million in excise taxes and $6 million in fees. And the argument is that that decision conflicted with a treaty with the Yakama Nation and the General Allotment Act of 1887. Fascinating that the tribes today, in the context of economic development and taxation, are still relying on treaty principles and the General Allotment Act, I think, and that today in the modern Ninth Circuit, they're hearing these decisions. There is a case relating to leases, the BLM, and extending leases for geothermal exploration in areas that were sensitive to the Pit River tribe that are going through the Ninth Circuit currently. And I think, and I think going to, I can't recall which professor mentioned this, there were, and I noticed this, I was sort of fascinated by it, in about 2015 and 2016, there were about 3 or 4 cases in the Ninth Circuit that were challenging disenrollment, primarily of the California rancherias and people who were being disenrolled by various tribal communities. And to me, I would just sort of keep my eye on where those cases were going, and I think they've since sort of fizzled out a bit. But there are, to be sure, and I like to share this information with law students because I like to have them think about the types of ongoing challenges in terms of litigation, actual litigation that starts its way either in a state or a federal district court and winds its way into the Ninth Circuit. I think it's really sort of fascinating. One of the cases that I've lost track of, and perhaps some of you have kept track of it, it was a case back in 2016 out of the area of Shingle Springs, where a federal district court judge in Sacramento held that a Shingle Springs tribal court order that gave guardianship of 2 Indian children to extended family members was not, it could not be applied outside the tribe's jurisdiction. And that decision was winding its way up to the Ninth Circuit, and I sort of lost track of it. So, I mean, there are some fascinating civil cases that are being brought in the district courts and winding their way up. In the limited time I have, I want to go to federal courts, and I want to spend most of my time in what I thought Professor Fletcher was going to talk about, is who is an Indian. So I think all of you know we have Major Crimes Act, and on those primarily 21 Indian reservations in Arizona, we have the Major Crimes Act that applies. And so currently, I'll tell you that I have about 185 pending cases in the month of August that are criminal. And in those cases generally break down to drug cases, immigration cases, firearms, violent crimes, sex acts cases, larceny. And in the category of drugs, firearms, violent crime, and sex cases are generally where you find the Indian defendants in the Major Crimes Act. Because usually if there's a firearm involved and you have a prior felony, then the Major Crimes Act will be charged, but then there will also be an additional firearms charge as well. One of the very interesting areas that I sort of observed, because it came to my attention in changed language in plea agreements that were coming through on these Major Crimes Act cases. And I sort of studied why is all this convoluted language about the person's Indianness? Because as a part of the Major Crimes Act, as you know, the element of Indian and Indian country have to be proven beyond a reasonable doubt. And so in the days when I was a federal prosecutor, we sort of applied the US v. Antelope standard, which is the person has to be enrolled in a federally recognized tribe. And that was easy enough. What we would do is we would produce a certificate of Indian blood, or we would get somebody on the stand to say, oh yeah, they're a member of the tribe, and their mother's, a member of the tribe, and so on and so forth. And it was fairly easy to establish that element. Well, fast forward to 2005, and the Ninth Circuit developed the tests. It's famous, the courts are famous for developing these tests. And so in United States versus Bruce in 2005, the Ninth Circuit established a 2-part test for establishing Indian status for Major Crimes Act crimes. They stated the defendant must, 1, have Indian blood, and 2, be recognized by a tribe or the federal government as an Indian. And presumably they were following the principles of Antelope. And so that was the state of the law for about 10 years. So have Indian blood, be recognized by a tribe or the federal government as an Indian. Then in 2010, in US versus Maggie, the Ninth Circuit was made to explain that the first prong of the Bruce test, Indian blood, meant that, quote, the defendant had some quantum of Indian blood traceable to a federally recognized tribe. And so that was the state of affairs for about 5 years. And then comes this case, US versus Zepeda. And US versus Zepeda was a Major Crimes Act prosecution in the District of Arizona, where the perpetrator, the defendant, was charged with a multitude of crimes, including a number of assault crimes and firearms offenses. And that individual had a certificate of Indian blood showing that he was a member of the Gila River Indian community. And on the certificate of Indian blood, it said he was derived from the O'odham and Tohono O'odham tribes. And so there was a challenge to whether or not the prosecutors met the elements of Indian for purposes of the Major Crimes Act. And in Zepeda, in 2015, this went to an en banc panel because the Ninth Circuit three-judge panel held that the government did not meet its burden of proving the element of Indianness beyond a reasonable doubt, vacating essentially the jury finding. And in Zepeda, the court said that, well, they examined what is required for proof of Indian status. And they looked at Bruce, they looked at Maggie, and in Zepeda, they explained that under the Bruce's first prong, the government need only prove that the defendant has some quantum of Indian blood, whether or not traceable to a federally recognized tribe, and clarified that the government must prove beyond a reasonable doubt that the defendant, one, has some quantum of Indian blood, and two, is a member of or affiliated with a federally recognized tribe, and the defendant must have been an Indian at the time of the incident. I don't know what that means. And a tribe's federally recognized status is a question of law for the courts. And so it's not unusual for the parties in a case to submit a question to the court, to have the court look at the list of federally recognized tribes and say XYZ court is a federally recognized tribe. Yes, they are, so that prong is met. But they overturned Maggie and they try to explain Bruce, and here's the interesting part of it. How many of you thought, and I think we discussed sort of the political distinction of Indians and who gets to determine who is an Indian. And I loved, and I wanted to see more of the examples of how you get to the definition of Indian. But what I found most fascinating in Zepeda, speaking of Judge Ikuda and Judge Kaczynski, they wrote concurring opinions in the judgment only. But I found this very interesting. Let me make sure. This is Judge Kaczynski. He says, by extending Bruce and overruling Maggie, the majority creates a disturbing anomaly in the application of our equal protection law. The majority empowers Congress to distribute benefits and burdens within Indian tribes along purely racial lines. Judge Ikuda observes, this is a troubling conclusion and an unnecessary one. The Bruce blood quantum requirement serves no purpose because the second prong of the Bruce test adequately defines an Indian based on his, quote, tribal government recognition as an Indian. In holding that a person is not an Indian unless a federal court has determined that the person has an acceptable Indian blood quantum, we disrespect the tribe's sovereignty by refusing to defer to the tribe's own determination of its membership roles. And essentially, she goes on to say, this has created now a race-based distinction. And so So then I go back to now today, I look at the practical plea agreements that Indian defendants are entering into, and as part of their factual statement of what happens, it states, and I have some quantum of Indian blood, that is, I have ancestors or grandparents who are members or affiliated with, Indian tribes. And it's for me, I think it's really kind of one of those areas that because of some of what we talked about in terms of the Indian Child Welfare Act and some of the other challenges in terms of disenrollment, I think this is probably going to be an area that will continue to develop into decisions by various circuits and ultimately go up to the Supreme Court. And it's going to be interesting to see in what form or fashion this takes. One of my friends, who's also a lawyer, I was asking her, what do you make of this sort of some quantum of Indian blood requirement? And she said, well, in some ways it almost expands. It could expand the reach beyond being an enrolled member of a tribe. And, but at the same time, it might actually kind of restrict the tribes or not look at what tribal enrollment really is. So I think it's a really kind of a provocative area of law that will sort of, I think, bear studying, and that will probably rear its head in other court decisions. I hope it's not my court. But in any event, I have found the position of being a district court judge in a very dynamic jurisdiction like Arizona to be intellectually stimulating and challenging, and at the same time it is somewhat concerning that when you do have questions of if you're dealing with a case that has some federal Indian law implications, there really is no one really to turn to in the district court other than your own self-study or what you've been exposed to. So I think it is a very legitimate question to determine whether or not there should be some, perhaps not requirement, but some application of Indian law principles into some of that judges' training. And I think it has to happen at all levels, especially with state courts that are in states like Montana, Arizona, New Mexico, Nevada, those that have robust tribal court systems. I think there has to be sort of that dialogue as well. I know that I am close to running out of time. I wanted to leave time for questions, just observations, questions, curiosities.
Oh.
Hi, and first I want to thank you for speaking here. And I was just wondering, I wanted to ask if you thought, or if you think whether the Ninth Circuit will rehear that adoption case en banc, or will they decide not to?
Yeah, I can't make any prediction about that. I think there are certain standards that apply. I know that in the one case that I heard and the decision that I wrote, there was a request for rehearing en banc, and I think a lot of those decisions are made independently by all of the judges that are deemed the en banc panel, and so they put out a request. The parties have or this party has requested rehearing. Submit your vote, And I, of course, wrote my decision and I thought it was right. And so I'm gonna say no, no rehearing. But I have no idea how any of the other judges voted. I knew how the judges on the panel voted because there were, it was a unanimous decision. But I don't know how any of the other judges voted. And so, and I really don't know, my sense is there are, sort of obvious questions that a judge will ask and probably have their law clerk study. Is this issue capable of, rearing its head again? And here, I think because of the mootness issue, I don't know that that's, I kind of think that that would probably be a hard yes to rehear. And I think the other part of that too was the district court judge made some really interesting observations, because I think in the underlying case, and this is why I think facts really matter in cases, in the underlying case there were allegations of abuse, and he said, look, the state court systems have, in that instance, they have the ability to address those types of concerns for those children. And so I think he sort of fashioned the argument that, look, there are all these possible areas of redress, that we don't have to get to the heart of the merits, that the claim that ICWA is discriminatory, because the children's interests are being taken care of under the process that was established. So I would be very surprised if they took it to rehearing. Everyone wants to go to happy hour, except for Professor Skabeen.
Yes. One of the things that I'm fascinated is, they said, Judge Kavanaugh, to recuse himself, and we all know that at the Supreme Court, it's up to them, there's no rules. But when it comes to you, for instance, let's say that, are there things where if you think the Hopi tribe is remotely involved, you have to recuse yourself? What is your understanding of it?
So what I did do is I added Hopi tribe to my recusal list. And I did that because I did some legal work for the tribe in private practice, and I also sat on the Hopi court. And I wanted to insulate myself from dealing with, and plus my father, before he passed, he had some service on the tribal council. I wanted to insulate myself from having to deal with any of those matters. But the interesting thing about that is I do still have Hopi individual defendants who will come through in a Major Crime Act case. And certainly if I recognize the name, or I look a little closer and see if I know the community or the parties involved, I'm going to recuse. But there is a Ninth Circuit case that talks about recusal, and in that case it basically lays out sort of the principles that, okay, yes, generally as a federal district court judge you have an obligation to recuse yourself when you think that there's going to be even an appearance of conflict. In the same decision, however, it says, but the district court judge should be always measured and cognizant of the fact that you're burdening some other judge when you do that. And so it sort of, makes you very much aware that if I recuse myself on all of these classes of cases, then what am I doing to my colleagues? And really, is that fair? And so I've had instances where, because I have practiced in private practice dealing with some water issues, when issues dealing with, the Central Arizona Project or things of that nature came about, I've put it out there to the parties, and surprisingly, some of them have said, oh, no problem, she can stay. And so you sort of leave it to, in some respects, to the parties as long as they're fully informed.
Okay, thank you, Judge.
Oh my goodness.
You made it.
I made it.
I promised I wouldn't step in front of that, but that, as the judge alluded to, brings us to the end of our symposium, and we are very glad that you were all here to experience this, and thanks again to everyone who came, and the law school for helping us, and everyone in the law for helping me out all day. And as we have outside, as she alluded to, we have food and also beverages available.
Great.